Good afternoon, everyone, and welcome to this meeting of the Justice and Human Rights Committee as we continue our study on counseling and other mental health supports for jurors. I've chatted with our witnesses who are here, but we have two witnesses that are joining us from afar. We have Mr. Mark Mossy, who is the Executive Legal Officer, Office of the Senior Judge, Judges Chambers from the Nunavut Court of Justice. Mr. Mossy, can you hear me?
I can. Good afternoon.
Excellent. Good afternoon. And a fellow West Islander, we have Mr. Paul Dorer. Is it Dorer or Dore, Paul?
It's Dore.
Dore. Like Mr. Paul Dorer, who is the Juries Commissioner from the Court Services of the State of Victoria, joining us from Melbourne, Australia. So thank you so much, both of you, for joining us from so far away. And then in the room, we have from the American Society of Trial Consultants, Ms. Sandra Donaldson, who is the Vice President. Welcome, Ms. Donaldson.
Welcome. Thank you.
We have from the Canadian Council of Criminal Defense Lawyers, Mr. Will Trudell, who is the Chair. Welcome, Mr. Trudell.
Thank you very much.
And as an individual, we have Professor Brian Bornstein, who is a professor of psychology and a professor and a courtesy professor of law at the University of Nebraska-Lincoln. Welcome, Mr. Bornstein.
Thank you.
So as I've explained to the witnesses in the room, because of video conference issues, just in case anything technical happens, I'd like to have the testimony of both of our witnesses on video conference first. So I'm going to start with Mr. Mossy, and then I will go to Mr. Dorer, if that is okay. Mr. Mossy, you have somewhere around 8 minutes, but if you go up to 10, I'll give you the latitude.
No, thank you, Mr. Chair. I don't think I'll be that long. So I would like to thank the committee again for my invitation here today. By introduction, my name is Mark Mossy. I'm employed as the Executive Legal Officer to Chief Justice Neil Sharkey of the Nunavut Court of Justice. I have lived, raised a family, and worked in Iqaluit since 2010. Prior to joining the Nunavut Court of Justice in 2015, I was a poverty lawyer with Malaganek Tukshinavik Legal Services, the legal aid clinic here on Baffin Island. And during my time in Nunavut, I have also served as president of both the Law Society of Nunavut and the Nunavut branch of the Canadian Bar Association. As articulated in my written brief previously submitted to the committee, I felt it necessary to draw on the experiences of fellow justice stakeholders in order to paint an accurate and compelling picture for the committee of some of the stresses placed on jurors as a result of the unique challenges Nunavut poses as a jurisdiction. While jurors in Nunavut are tasked with the same complex and emotionally taxing burden as Southern jurors, I should note my reference to Southern in this context is to Canadian jurisdictions below the 60th parallel. Nunavummiut performed jury duty in much different conditions. It was interesting, though not surprising, that the responses I received from justice stakeholders to my request for input on this subject were consistent in their themes. The responses told a universal tale of suboptimal conditions for jurors to deliberate, financial and childcare burdens being placed on jurors, and an emotional toll being taken on by jurors in small, isolated communities where entire populations sometimes only total into the hundreds, who are asked to sit in judgment of fellow community members who are often friends, acquaintances, or even relatives. Jury fatigue and the follow communities are forced to deal with alone after a jury convicts a community member and the court party immediately leaves to head home to Iqaluit were also identified as stress situations for Nunavut's jurors. As to not simply repeat what was submitted in my brief, I think it is imperative to draw attention to how Nunavut's unique challenges, from geography to climate, isolation to poverty, have an exponential impact on stresses already built into the jury system in Nunavut. I am sure that any assistance to jurors that may result from this committee's work will be greatly appreciated by both jurors and justice stakeholders alike. I thank the committee again for the opportunity to appear before you today, and I'll be happy to answer any questions that I may be able to assist with. Thank you, Mr. Chair.
Thank you very much. We appreciate that. Mr. Dorer.
Good afternoon, and thank you for the invitation to contribute to this committee's work. J'ai grandi dans le West Island de Montréal.
I grew up on Montreal, West Island, at a time when Anglophones did not have to communicate fluently in both official languages. And then I moved to Melbourne only a short time after the Habs last won the Stanley Cup. So I would like to apologize to all Francophones in the room that I will need the services of the interpreters that are here today.
These bring the values, standards, and expectations of our community into the courtroom, and they contribute in a significant way to the administration of justice. The Juries Act establishes the Juries Commissioner role and as many deputies as required to administer the Act. The Juries Commissioner's Office ensures a sufficient number of Victorian citizens, broadly representative of the community, are available to serve as jurors in Supreme and County Court trials. There are 14 jury districts across Victoria. Melbourne is the largest by far, with 13 other regional locations of varying size and capacity. While civil jury trials are still available to parties, most jury trials are in the criminal jurisdiction, and most are heard before a judge of the County Court of Victoria. The Juries Act deals with compensation for injury during jury service and states if a person suffers personal injury arising out of or in the course of jury service, compensation is to be paid. Our duty of care under this section of the Act extends to anyone attending for jury service, whether impaneled on a jury or not. In any given year in Victoria, approximately 170,000 people are randomly selected from the Victorian electoral roll and receive a notice of selection for jury service. This notice includes a questionnaire whereby we assess citizens' eligibility as prospective jurors. We provide citizens with an opportunity to apply to be excused for good reason. From there, approximately 70,000 people are summoned for jury service. At this stage, citizens are again given an opportunity to apply to be excused. A few months from first receiving their notice of selection, approximately 20,000 people attend courts across the state as summoned. In groups called jury pools, they sit through an orientation, and we reinforce information previously given regarding our expectation of their availability, reminding them of their opportunity to apply to be excused. And then in groups called jury panels of 25 to 40 people, they go into courtrooms for the empanelment process. This occurs approximately 600 times a year, as we have about that many jury trials, of which less than 100 would be civil trials with juries of 6 people. On that math, about 6,600 Victorian citizens a year serve as jurors. Most people find the jury service rewarding, and most leave with a sense of achievement. Others find the experience not so rewarding, and we tell them that this is understandable. As this committee appreciates, jury service represents a significant disruption to a person's life. Jurors are away from their work and home environment, sometimes for weeks or even months. They listen to and digest evidence, often detailing the most horrific of human behavior. They discuss these details with 11 strangers in foreign surroundings, and we ask them to reach a verdict, the impact of which will resonate with the accused, the victim or victims, witnesses, and many other members of the community for years to come, or forever. This is something most people will never experience, and for some who do, we understand it may take some time and support to process that experience. Victoria has had a juror support program since 2004. For the first many years of this program, the default approach was telephone counseling, but face-to-face sessions were offered as deemed necessary by the counselors. Our service provider was a small 2-person operation, but very professional, competent, and always available. The only issue? They were Melbourne-based, which limited the opportunity for in-person counseling for regional jurors. In late 2015, we negotiated an agreement with the provider of Court Services Victoria's Employee Assistance Program, whereby the same type of service offered to employees became available to citizens participating in jury service. This current provider leverages a network of counseling services across the state, offering counseling and coaching support by qualified and registered psychologists and social workers. There is a telephone number operating 24/7 that jurors call to book an appointment. If a juror indicates an immediate need for support, or the call center attendee suspects there's a need for immediate attention, a telephone counseling session is arranged as soon as possible. But under normal circumstances, jurors use this phone number to book a counseling session, which can be arranged to take place in person, via telephone, or through a video conference connection, according to the juror's preference. Our approach is as follows. There are no restrictions as to why a juror could access the juror support program. It could be to seek support after hearing evidence in a trial, to work through personality clashes with other jurors, or just to talk about their experience without breaching jury confidentiality. The program can be accessed by anybody who attends for jury service, whether selected on a trial or not. Legislative duty of care aside, our experience is that the arraignment process has the potential to harm one person as much as a 2-week trial may affect another. The counsellor has the discretion to schedule as many sessions as he or she deems necessary for individuals, but we have an arrangement whereby a senior clinical manager will call me should an individual need more than 4 sessions. To date, January 2016 to December 2017, the uptake is as follows. In 2016, we had 17 jurors access the program. 14 were from Melbourne and 3 were from regional Victoria. 9 of those chose face-to-face and 8 of them chose to go through the telephone. In 2017, we had 8 people access the program, 6 from Melbourne and 2 from regional Victoria. They 5 of them chose to access it face-to-face and 3 by telephone. The average number of hours per juror is just over 2 hours per juror. And the issues that were presented, and these are broad categories, in 2016, 4 people presented with trauma, 10 with personal stress, and 3 with anxiety. And in 2017, 4 presented with trauma, 3 with personal stress, and 1 with anxiety. All issues presented related to or were triggered by the court cases. That is, all 25 people who accessed the Juror Support Program over the past 2 years had been impaneled on a jury. I want to thank you, the committee, and you, the chairman, for this opportunity to present to this committee, and I look forward to answering any questions you may have.
Thank you very much, Mr. Dorr, and thank you very much for getting up so early in the morning to do this.
Thank you.
We're going to move on to Ms. Donaldson. Ms. Donaldson, the floor is yours.
Thank you very much. I'd like to say thanks to the committee for inviting the American Society of Trial Consultants to speak to you. I understand that trial consultants are rarely used in Canada, and perhaps after speaking today, that might change a little. Many brilliant and skilled professionals have spoken to this committee. They have presented many ideas, many solutions, and much data. I am not here to go back over all of that, but what I would like to do is talk to you about how we can make a difference during the jury selection process, in particular in identifying and eliminating potential jurors that end up being in these situations of experiencing high stress. So it's more of a preventative measure. Let me give you a little background about who I am. I have a PhD in psychology from the University of North Carolina in the United States. I've been a practicing trial consultant for 32 years, all of which, up until December, were within a law firm, Womble Bond Dickinson in North Carolina. So while there, I created a trial consulting business and not only helped the lawyers in that firm, which is a very large law firm in the East Coast and now worldly, but also I had other clients. It's the kind of business where if you do good work, it gets you more work with the next person down the street, which gets you more work. I've participated in many trials. Just for one client who is faced with 30 years of mass tort litigation, I stopped counting at 150 trials. So I am bringing to you a lot of personal experience of being in the courtroom at trials, and probably have participated in more trials than most of the attorneys that I have worked with over the years. Let me also tell you a little bit about the American Society of Trial Consultants. ASTC was formed in 1982 when a group of 24 professionals met in Phoenix, Arizona to meet and share their experiences in a new profession, jury consulting. The group grew over the years, meeting yearly to share their growing wisdom. Today, AST has about 300 members. We are called jury consultants, trial consultants, and litigation consultants. Most frequently, we referred to as jury pickers. Although we'd like to think of ourselves as selecting or picking juries, the reality is that the process is one of deselection, both sides aiming to remove those jurors who are unsuitable for rendering an impartial verdict for their client, and hope that, when finished, they have a group of open-minded, unbiased jurors to decide the outcome. The main mission of the American Society of Trial Consultants is as follows. Our legal system is based on the principle that each party putting forward the best case, making the most of facts, law, and presentation skill, allows the truth to win out far more often than not. In that kind of a system, the goals of the ASTC lie at the very heart of the law's ability to deliver justice. We help litigators become better at persuading jurors and other fact finders, and that makes the system work in a way that is more meaningful, more reliable, and ultimately more fair. Not all trial consultants in the United States are members. It is an unregulated profession with no credentialing. Those who are members of ASTC are expected to uphold certain ethical standards and practice guidelines. ASTC established the only set of ethical principles, and practice guidelines that exist in this unregulated profession. It developed a statement of shared values that are intended to inform the professional judgment of the working trial consultant striving for the highest professional ideals. Among our principles, members of ASTC are expected to conduct themselves at all times with professional integrity, personal dignity, and respect for the legal system. They are expected to uphold professional standards of conduct and clarify their professional roles and obligations. They comply with the law and encourage the development of law and social policy that serves the interests of their clients and the public generally. And we maintain the integrity of the jury pool. In other words, we do no harm. The right to a trial by jury should not mean it's at the expense of jurors' emotional well-being, but sacrifice they do out of a sense of civic duty, which to this day I find absolutely amazing. To give you an example, I participated in a civil trial in Minnesota that was expected to last 4 months. The judge was insensitive to hardships and bias. There was a 100-plus item juror questionnaire and lengthy voir dire by counsel for both of the parties. We had a lot of information about these jurors. For example, we knew one juror worked 2 jobs so his son could go to college. Serving would mean the elimination of one of the jobs. Another would not be paid for jury duty. These jurors were not removed for cause by the judge, and peremptory challenges were focused on eliminating very biased jurors. For example, a research clinician who had received a grant from the government to study the very product that was at issue in the trial. The concern was a person of this nature is going to be the expert in the jury room, and the decision will be based on information other than what was presented. These, the hardship individuals we just expected in a 4-month trial, eventually they would just drop off. They just would not be able to withstand it. Surprisingly, they all stayed for the 4 months. The one juror with the son in college, the son withdrew from college that semester so that he would not be a financial burden on the family. The juror that was not paid, the jury itself took up a collection and paid his house payment 1 month. That is a sacrifice beyond what any juror should be asked to do. But they did it. Minnesota is one of the few states that has a very strong civic duty, and they will do anything to fulfill that civic duty. While some people watch YouTube videos on how to get out of jury duty, others make the commitment to serve. Minnesota has an exceptionally strong sense of doing one's civic duty. Of interest is that it was the judge that actually had a mental health breakdown after the trial. Most people experience some stress when placed in new situations such as jury duty. Jurors are people plucked from the various life situations. Although they have seen court proceedings on a variety of television programs, reality is never like Hollywood. The show Bull currently on television is nothing like what goes on in a real courtroom, or is it a good example of what we do as professionals? For some, there is no frame of reference to help understand and control the situation. And we know that stress is reduced if an individual feels they have some control. Although most jury duty is a low-stress experience, certain types of jury service can produce higher levels of stress. Those that are particularly horrific crimes with gory crime scenes are sometimes very difficult to overcome. But even in civil trials that will last for a long period of time are difficult. I had 2 trials where jury selection took 4 months, and then the subsequent trial was almost a year. And then I had another case where jury selection lasted 15 months. We went through over 1,400 jurors to impanel the jury panel, and the trial then lasted for a year and a half. So this is a huge time sacrifice that people make. In all of those situations, though, there was no juror who complained of extreme stress or reacted with PTSD. Most symptoms of stress related to jury duty go away in a day or so in the life of as the life of a juror normalizes. Even in those exceptional situations mentioned above, not everyone suffers to the degree that PTSD is experienced. Paula Hannaford-Agar cites that 70% of all jurors report some stress, but it's only 10% that report high levels of stress. So a lot of what the committee is focusing on is that 10%, the people who have the highest levels of stress. So how do we uncover that 10%? Well, in the U.S., Canada, Australia, and England, there is the right to a jury trial, yet only the U.S. allows voir dire beyond judicial inquiry, the questioning of prospective jurors in a trial to determine their suitability for rendering a fair and impartial verdict. Jurors are presumed to be fair and impartial. In most countries, they just pluck 12 people from the community or whatever their number is, and they are left to decide the outcome of a case. Voir dire in the United States is the process of probing jurors' state of mind that might provide grounds for excusal. Jurors can be excused from serving because the trial will be a financial burden, for child or adult care duties. They hold essential public jobs like firefighter or policeman, and for bias that could be a prejudice against one of the parties. Jurors with experiences too close to home, for example, have a family member the same age as the victim, observed someone, or they themselves have been sexually abused, assaulted in the past, are at the mercy of sufficient questioning and the court's mercy to be excused. The AST has a special practice section called jury selection. And in it, it says that in preparation for jury selection, trial consultants may perform a variety of functions, including but not limited to conducting pretrial research with respondents who meet the criteria for jury service, preparing profiles of juror characteristics believed to be positive or negative for the client, preparing voir dire questions to be submitted to the court or to be used by counsel in conducting voir dire, preparing a juror questionnaire to be submitted to the court, and lastly, in making recommendations for improving voir dire conditions. So we're actively involved in trying to create a situation in which it'll be a fair trial and the jurors that serve are suitable to serve for whatever reason. One of the things that we find is that judges have a lot of control in the United States over the jury selection process. Federal court is a little more controlled with generally judicial questioning. Attorneys are allowed to submit questions in writing. The judge will sometimes ask the question and sometimes won't. State court is a little better in that there is attorney voir dire. The time can be controlled. In some cases I've had where a juror can go on for weeks questioning jurors before the panel is passed to the other side. People in general are poor predictors of their feelings or behavior. You may think that you can set a bias aside or be able to view graphic evidence, but when that bloody photo of a child's badly abused body, who is the same age as one of your own children, is shown, a connection can be made, and feelings of that juror that they're unable to control. So, how do we help jurors realize that they're going to have difficulty serving in a particular case? Well, we structure the situation to identify and uncover those jurors who are going to have difficulty. And it's through proposed questioning. If you're not able to ask a certain amount of questions, jurors are not going to just come out and say, oh, you know, I observed this or was a part of this situation in my past. I don't think I can be fair. Because everyone thinks they can be a fair juror. Everyone thinks that they can set the information aside. So you have to help the juror uncover their own potential biases. So questions we can ask, such as, do you have any medical, physical, or psychological conditions that might interfere with your ability to serve? That might be something that you ask in judges' chambers. You have not seen the evidence, so it's difficult for you to predict how you will react. How do you typically react to watching horror or particularly violent, bloody TV or movie scenes? Do you keep watching, or do you close your eyes and turn your head the other way? Have you ever watched something horrific and had it affect you for some period of time? Some people have a difficult time viewing cases involving abused children or bloody crime scenes or autopsies. Others are able to separate themselves and have a more clinical experience. Which of these best describe you? So these are questions that, depending on the jurors' answers, they wouldn't thought of to just come out and say themselves. But once this is said, and with further exploration, these are jurors that might experience the kind of harm you're talking about and get them off the jury. So, as a conclusion, I would like to recommend some suggestions that Canada might employ, which is improving and allowing more voir dire in the judicial setting to help identify and uncover those jurors that could be harmed. Include attorney voir dire and written juror questionnaires so that they can uncover these things privately rather than stating them publicly in front of everyone. Get an advance notice of the trauma that's involved in a case. We've done things such as cover the face of a juror, or we have explained something but in a model format as opposed to the actual crime scene evidence. A consultant that I know in a mass shooting case would use paint gun examples as a way of demonstrating a mass shooting, but it's not involving the actual people. It's more the strategy that was involved. So I would like to make these recommendations. I know that they put a burden on the system, but there are things that can be of a preventative measure. Thank you.
Thank you very much, Ms. Donaldson. Mr. Trudell.
Thank you very much, Chair, members of the committee. It's an honor to be here once again on behalf of the Canadian Council of Criminal Defense Lawyers. I am, on behalf of the Council, I think I can say, and as a defense counsel, we are very pleased that the committee is studying the issue of jurors and how to help jurors, because I think we would all agree that it's probably one of the most precious aspects of a democracy to be judged by your peers. I think, however, that the work that you're doing may uncover some suggestions, as we've just heard, as to how we can do things a little bit better. What I would say to you is this, and I'll keep my comments brief in the beginning. I think we don't do a good job in the front end, and I don't think we do a good job in the back end in relation to jurors. You're not going to be surprised to hear that I get calls from persons who say, oh my God, I've been summoned for jury duty. How do I get away with this? Or how do I get out of it? And then, of course, it's almost universal that if you talk to a juror who has served, they will say it's the most incredible experience of their life. But we have mystery going in. So I think that one of the things we should consider is enlightening the jury array when they are gathered by telling them what their role is, not waiting for it to happen in court. Remove some of the mystery. If a case is going to be a horrific criminal allegation, I think the jurors can be prepared for that by persons who meet with the array before they are called into a courtroom, so that they can understand that there's a prisoner's box there, and you might see an accused person come in and they might even be in handcuffs in a particular case. So it takes away the mystery. Just that jury box, why does that person have to sit there? Well, judges may not have an opportunity to explain it. I'm really happy to hear Sandra talk about the depersonalization of information that jurors have to give. So you're standing there and a juror is called up and they say, my husband is ill, or I don't think I can afford childcare. That should all be done in a questionnaire. And I can tell you that one of the most sensational cases that we've experienced in this country, there was a questionnaire with a little brief description of the case, and I'm talking about Bernardo, so that when a person came up, the defense, the Crown, and the judge had the questionnaire. And the judge and Crown defense could all agree that this juror should be excused without the juror have to explain some of the personal trauma that they might experience. I think that at the other end of the case, judges, I think, are doing this more often. They're going in, they're talking to jurors, explaining, thanking them for their work, explaining how important their role is. But I also think that we haven't provided, except on a part-time basis, if I can use that phrase, as a result of the pressure that Mr. Ferrand brought in Ontario, and Ontario responded. We need to provide, in my respectful submission, therapeutic assistance after the case is over, after the sentencing, after everything is done. I think the jurors who need to have some therapeutic sessions, it should be provided and it should be paid for. And one of the problems that we might sort of pay attention to, and some of the doctors and the psychologists and psychiatrists might help us with this, you may not understand what effect that trial had on you for years, because we don't know how we're absorbing it. So I think that probably one of the issues is, one of the important vehicles in this country is something called Let's Talk Day that we just experienced. Everyone is encouraged through Bell Canada's program to talk. But at the end of a jury trial, we sort of put a lid on the jurors and say you can't talk. So I would think that one of the things that you may consider is reconsidering Section 649 of the Criminal Code. And there should be an escape provision, exception, for persons to talk about their deliberations for therapeutic reasons. And the exception is for the former juror, not the psychologist, not the provider of therapy, but the juror. And I think that would be a simple amendment, carefully drafted by clause experts, but it would allow jurors to let's talk about what they experienced in that room. And I think that becomes a very important aspect, and it's almost the one thing that the federal government can do. I mean, the provinces are really responsible for how the jury system works, but I think we need to do better up front, because jurors come into the courtroom wondering who we are, and they have their own view of who we are, and we have our own view of who they are, and we have certain information. And some jurors have already made up their minds in some respects. So let me give you an example. In a case I had, a murder case, quite some time ago, the judge said to the panel, this case could take 2 or 3 months. And then a juror was called, and I watched the juror walk up, and he was obviously uncomfortable. And when he got into the witness box to be challenged for cause, because it was a unique case, I said, I apologize, sir, but when your name was called and you came up, you seemed to wince or be uncomfortable. I apologize, but was I right? And he said, I said, His Honor said this case would take a long time. And he said, well, yes, actually. I don't think I can put up with you people for that long. We chose them. But it is the most humbling experience to be involved in a jury trial, and one of the most precious experiences for the jurors. But we need to take the mystery out of it and protect and enhance this essential aspect of our democracy. Thank you.
Thank you very much, Mr. Trudell. Mr. Bornstein?
Yes, members of the committee, thank you for the opportunity to speak with you today on this important issue. I agree with Mr. Trudell that it speaks very well of the House of Commons that it is examining this topic. I'm a professor of psychology and law at the University of Nebraska-Lincoln, where I've been on the faculty since 2000. My major research focus is jury decision-making, and I've been investigating and writing about juror stress and well-being for over a dozen years. I've divided my remarks into three sections: symptoms and prevalence of juror mental health issues, causes, and interventions and benefits. My generalizations today are drawn from a body of research that has largely been conducted in the U.S. Canadian jurors' experience might differ due to the many differences between countries in jury selection, trial procedures, and the kinds of cases that result in jury trials. But I expect that many aspects of the experience would be similar regardless of nationality. The symptoms of juror stress are much easier to describe than the prevalence. Stress, anxiety, depression, perseverative thoughts, and impaired sleeping and eating are the most common negative symptoms that have been found in the literature. In the vast majority of jurors, these symptoms fall short of the threshold for a clinical diagnosis, but in rare cases they can be severe enough to satisfy the criteria for an anxiety, depressive, or post-traumatic stress disorder. Jurors' reactions necessarily vary across individuals. Some people are naturally more sensitive or resilient than others. For example, several studies have found that women jurors report more and more severe stress symptoms than men jurors. The exact prevalence of juror stress is hard to pin down because of the enormous variability in the kinds of trials and in how researchers measure stress and well-being. But a rough ballpark figure is that 1/4 to 1/2 of jurors experience some type of negative reaction to some aspect of their jury service. That figure is probably an underestimate given the general tendency of most people to want to appear in a positive light. Because trials vary so widely, it makes more sense to talk about factors that are more or less likely to cause stress than about the overall prevalence. Certain features of trials pose a greater threat to jurors' well-being than others. Causes of juror stress range from the common and mundane to the rare and excruciating. Research that I conducted several years ago, along with a number of other studies, has identified 7 different categories of stressors. In descending order of frequency, they are: first, disruption to daily life, such as having to manage jury service along with one's work and personal life, such as the example Ms. Donaldson gave of the man who had to work 2 jobs while serving as a juror, as well as the low rate of juror pay in most jurisdictions. Second, trial complexity, such as difficulty understanding expert testimony or jury instructions. Third, reactions to evidence, such as gruesome photos or testimony. We tend to think of this most often in terms of violent felony cases, but it also comes up in civil cases involving grievous injuries to plaintiffs. Conversely, evidence can be so tedious and boring that it is hard for jurors to sit through it. Fourth, difficulty making decisions, or what I sometimes like to refer to as the burden of justice, such as fear of making the wrong decision or an awareness of what a particular verdict would mean for the parties involved. Fifth, general jury duty factors, such as not understanding how the whole process works, who the various court personnel are and what they do, and just generally feeling somewhat lost. Sixth, juror interactions, such as heated disagreements during deliberation, especially if one takes a minority position, as well as negative interactions with courtroom personnel. And seventh, external sources such as fear of reprisal or media attention. Media attention in particular is increasing as the demand for online news grows and social media make it ever easier to disseminate information. Some of these factors will almost always be present in jury trials, such as unfamiliarity with the process and disruption to one's daily life, whereas others will only occur in certain cases, such as complex evidence and media scrutiny. And some of these things are easier to address than others. Means of reducing juror stress can be categorized as those that take place pre-trial, during trial, or post-trial. Pre-trial techniques include juror orientation programs, warning them about or even exposing them to potentially upsetting evidence, and private individual voir dire. These processes have been found to reduce stress and increase juror satisfaction. Individual voir dire before a judge in chambers also increases the rate of disclosure of possible bias or conflict. During trial, jurors could be allowed to ask questions, take notes, and discuss the case with one another prior to deliberation. Many jurisdictions have also experimented with simplifying their jury instructions. Studies show that these things tend to increase juror satisfaction without having an adverse impact on verdicts. Post-trial techniques include debriefing sessions led by the judge or mental health personnel, such as the program described in Victoria. Jurors tend to appreciate the opportunity to vent afforded by a debriefing, and judges also find debriefing useful, but how much it alleviates any actual symptoms of stress is somewhat unclear. The problem is that very little research has addressed the effectiveness of these various interventions, and in considering the benefits of reducing juror stress, it is necessary also to consider the costs, especially in terms of time and money. For example, creating an orientation video is a one-time expense that requires relatively little time to create or show to jurors, but post-trial debriefing would be a significant time investment by judges and jurors and a significant expense if led by a mental health professional. Some of the benefits of reducing stress are obvious. The state has an interest in citizens' well-being and should not impose threats to their well-being of long or even brief duration by requiring them to perform a civic duty like serving as a juror. But there are less obvious benefits as well, although the relationship between stress and decision-making is complex, and some research suggests that a moderate level of arousal can benefit cognitive performance. Distraught jurors do not make good decisions. Stressed out or anxious jurors are likely to be preoccupied and distracted from the task at hand, increasing the risk of inattention and poor comprehension that can contribute to a miscarriage of justice. There is also an efficiency argument to be made. Highly stressed jurors are more likely to have to be replaced, requiring the selection of alternate jurors. Negative experiences with jury duty perpetuate the myth that it is a duty best avoided, posing challenges for courts to obtain sufficiently large and diverse jury pools. And because after jury service it is generally viewed positively and increases trust in government and other types of civic engagement, anything that deters citizens from serving on juries can have ripple effects. Finally, although the focus of today's hearing is on juror stress, I wish to close by emphasizing that jurors are not the only ones whose well-being is at risk from what transpires in the courtroom. Attorneys, judges, and other court workers also make difficult decisions and are exposed to upsetting information. These personnel may face additional stressors that do not affect jurors, such as security concerns and burnout. Their well-being should also be addressed. Thank you.
Thank you very much. And I want to thank all of our witnesses for your very cogent testimony. And now we will move to questions. We're going to start with Mr. Cooper.
Thank you, Mr. Chair. Thank you to the witnesses. I'll begin with Mr. Trudell. You touched upon Section 649 of the Criminal Code, and you recommended that an exception be made whereby jurors after a trial could, upon seeking counseling, discuss their deliberations and other aspects of the trial within the confines of Section 649. So I was wondering if you have any thoughts about during trials. Would it be a concern, for example, from the criminal lawyer's standpoint, for a juror who is seeking counseling during a trial? Because, for example, in the province of Alberta, the program provided in Alberta does allow jurors to seek counseling during a trial to discuss aspects of the trial, or would that potentially result in significant prejudice in terms of a juror's ability to deliberate and reach a fair decision based upon the evidence at the trial?
Thank you very much for your question. I think that it is not a good idea to be able to allow a juror during the course of a trial to seek outside guidance in relation to the stresses they're having performing their duty. And I think that's one of the reasons why judges may have alternate jurors handy in a major case. The magic of the jury system is that they are able to gather almost as a family, protected to make their deliberations. So I think that I didn't know that it was done in Alberta, but I would like to sort of look into that a little more. But I think that it's very dangerous to do that. If someone is having difficulty and they need therapeutic assistance as a juror during the middle of a trial, I think that they're going to have difficulty performing their task, and I think that they should be excused.
Okay, thank you for that. And I'm now going to turn to, from Australia, Mr. Dorr. You talked a little bit about the juror support program in Victoria, and you cited some statistics. 17 jurors used the program in 2016, 8 jurors or 18 jurors, I don't know if it was 8 in 2017. That just seems like a really low number. Is there any explanation for this? Because the evidence that we've heard from a number of witnesses, including here today, wherein Mr. Bornstein indicated that at least half of jurors have some negative feelings or negative impact as a result of their jury service, and yet in the face of what seems to be a fairly common problem, even as Ms. Donaldson indicated, 10%. 17 jurors in 2016, 8 jurors in 2017, that's staggeringly low, but it is interestingly consistent with evidence that was brought to the committee from Ontario, where I think since they started their juror support program, I think there's somewhere in the neighborhood of about 7,000 jurors each year in the province of Ontario, and yet only somewhere in the neighborhood of 20 or so people per year have used the program. So I'm just very interested in that.
Yes, thank you for the question. I'm not too sure how to answer it in that I'm surprised as well by the low numbers. In fact, sometimes I wish that all 6,600 jurors accessed a juror support program after jury service. I think the answer lies in something that both Mr. Trudell said and Ms. Donaldson said. We do what Mr. Trudell was suggesting should be done in the front end. So I don't know if you remember the numbers, but we start with 170,000 people that are randomly selected, and only 20,000 people actually show up to a courtroom. So we have accepted applications to be excused on a personal basis, on a one-to-one basis, of many citizens for all those reasons that could maybe lead to stress should they end up on a trial, such as financial impact. Now, in Victoria, the employer is obliged to make up the pay to which a person would reasonably expect to be paid had they not been on jury service, and that obligation has got no end to it. So if you're on a 9-month trial, your employer is obliged to make up your pay. But we will excuse people who work for small businesses or self-employed, or where that financial burden might be there. If you care for children or other people in your family, we don't ask you to upset your life entirely. So we have weeded out, for lack of a better word, a lot of people who might otherwise be stressed or have an impact as a result of serving as jurors. So once they're on a jury, and we do a lot of that front-end work in our orientation, so we are continually communicating with people along the way about what they can expect in a courtroom, not the details of the trial, but who's in the courtroom, what they can expect, how things run. And so once a panel of jurors, 30 or so people, show up into a courtroom, and that now they're in the hands of a judge, and the selection process has to occur, and peremptory challenges are there, and and people can apply to be excused. Judges should be pretty confident that people are only going to be excused on the basis of those of the detail of that trial. And at that point, if a person feels that they can't sit through a trial, it's too the subject matter is too close to home, or they know something about the trial, they can apply to the judge to be excused from that trial. And finally, they can do that. They do not have to do it. I think, as Ms. Donaldson suggested, they don't have to do it in open court. Judges now, it is very unusual for a judge not to offer everybody the opportunity to write your answer down, and the judge will excuse that person without reading it in open court what the reason is. So I think that's probably why the numbers are low. I think the numbers should be higher. We're promoting the service more recently, so I'll let you know how we go in the next couple of years.
You're at 7.5 minutes, but Mr. Trudell, you want to chime in, and then we'll move to the next question.
I just wanted to say that if we looked at some of the major criminal cases in Canada, let's call them the horrific ones that we all probably are familiar with, you probably will find that not very many jurors wanted the help on a continuing basis. And I think one of the reasons for that is judges go a long way to sort of break up, for instance, the presentation of graphic evidence. They would be conscious of the breaks that the jurors need. And we have very talented judges in this country who know how to deal with these kind of cases. So if a judge knows this is coming, and it knows it could be pretty hard, and he's already prepared for it, there's a lot of effort directed to the jurors during the trial to protect them, make sure that they have breaks, et cetera. And I think that's one of the reasons why there aren't that many people who need the access right away. Of course, it affects us all. A defense counsel, and I'm pleased it was her, it affects everybody. I mean, as a defense counsel, you're seeing a murder take place, and it may not resonate for quite some time. The same thing applies to jurors. But we're doing a job. Jurors are looking at, seeing it, listening to it. But I think that the role that the judge has taken, carefully making sure that there's a balance, contributes to the lack of need for the jurors after.
Thank you very much for that. Mr. Fraser.
Thanks very much, Mr. Chair. Thank you all very much for your interesting words. I appreciate it very much. Mr. Trudell, I just want to turn back to Section 649 that you referenced. My understanding of that provision of the Criminal Code is to ensure that there is confidentiality about what discussions take place in a deliberations of a jury, and so there's good reason for that, and to ensure that full and frank conversations about how they arrive at a decision is kept in that jury room. If an exception is made for therapeutic purposes, as you say, or whatever wording could be used so that a person could seek some help to talk about the discussions that took place in that room, is it your understanding that that information would obviously be confidential with a mental health professional or whatever, but is there what would your opinion be about the compellability of that witness? Would it be privileged information and not admissible in court in any future proceeding? Or any appeal, for example, on things that happened in the jury room?
Well, we have to be careful about making sure that the case is over before the juror is allowed to have the therapeutic contact. So it can't take place prior to sentencing. It should take place when the case is entirely over. Maybe it's after an appeal. But I scribbled something on the plane, and I said this: this provision does not apply to communications by a member of a jury for the purpose of therapeutic assistance as a result of their experience serving as a jury member. The provision continues to apply to any person receiving such information. So it's very clear that it's the juror's protection, and let's just say, for the purposes of this discussion, that there was a situation where some litigation took place after, and a therapeutic provider was on the witness stand and asked to divulge. My respectful submission would be, he would say, I can't. you would say, I'm bound by my Socratic oath, and it's almost like solicitor-client privilege. And the only difference is the juror cannot waive, right? That, we'll call it privilege just for the purpose of this discussion. So I think that if the criminal code was amended to be very specific in words that we all understand, I think it might sort of accomplish what we're trying to do here. There will be problems probably down the line, but I think
We had heard it as well, and I'll turn to you just in a moment, Ms. Donaldson, for your thought on that. But we'd heard as well that it sometimes can be therapeutic for jurors who stay in touch with other jurors from the same case to discuss the matter afterwards, that could be therapeutic. Do you see any value in that, or is that going down a road we don't want to go down?
if we weren't living in an age of social media, if we could control the dissemination of the information. So let's say, who are you talking to? I was talking to the juror that I served with on that murder. Well, what did you talk about? So I just think it's very slippery. It's a problem because we ask jurors to come into the courtroom, take an oath, and then leave. We can't give them escape hatches because we have no control. As soon as I say something to you, you and I may be dealing in confidence, but it may go someplace else and there's no control over it. So I don't think that's
Never happened in politics, so we have no experience on that.
not in this country, with great respect to my friends.
Ms. Donaldson, you wanted to, I want to give you a chance to say something on that.
In the United States, once a juror is done with a trial, the judge says you are free to speak with anyone you wish to speak to about your experience. So they do have the opportunity, and I've conducted a lot of post-trial juror interviews, and the jurors, particularly in longer trials or particularly traumatic trials, become close friends and support units for each other. And that support system helps alleviate the need for counseling because they do have someone they can reach out to who experience the same thing. And there's a movement going around in court reform that is testing whether or not jurors should be allowed to talk about the trial during the course of the trial, whenever they're in the jury room, that they could start to talk about some of the evidence and what they're seeing. With the idea that if it was an interactive, ongoing process, they ultimately have to reach a decision. The opposite side of that is, of course, concern that there's undue influence by one particular juror or their misunderstanding of evidence that would affect the verdict.
Thank you. Do I have more time? Okay.
Another minute.
Mr. Bornstein, if I could ask you, we'd heard some evidence in previous testimony that jurors basically feel like after a verdict is made in a criminal case that their job is done, they're shown the door, and out they go. And they don't know what the resulting sentence might be. They don't know anything more about that case. Do you think that it would be helpful for the court to actually keep them informed about the rest of the matter after they walk out the door as part of the debriefing process? Or is it better to just let things go?
I think it would definitely be beneficial to give them more information as opposed to less. And the jurors that I've talked to have very often had a lot of questions about things. What's the eventual sentence going to be? Why didn't we hear about this sort of evidence? And when they've been allowed to talk to the judge in some sort of debriefing afterwards, they can often get those questions answered. They might not be able to, depending on if it raises a legal issue and so forth. But one of the things that does bother jurors in many cases is just not knowing some of those things like you're talking about. So I think it would definitely be helpful. What works against that to some extent is that after the trial is done, some of the jurors are just done. You know, they've given over a significant part of their life or however long the trial has lasted dealing with this. They're behind on work. You know, they've had to pay babysitter for extra time. And when I've tried to collect data on jurors after the trial, it's a pretty even split. About half of them, are very eager to talk about it, and the other half say, I've given my week over to this, and I just want to get home and deal with all the other stuff I have to deal with. So those are going to be competing factors.
So it's now Mr. Rankin's time. I'm sure we'll get more questions, Mr. Trudell. That'll come back.
But I'm out of time.
Well, we'll do after we finish this round. We'll do a round where everybody can ask. So go ahead, Mr. Rankin.
I appreciate that because it was just fascinating, and I understand the frustration my friend feels. I want to start with Mr. Mossy, if I could. Thank you for being with us, particularly given the realities of Nunavut and the remote communities. Often I'm guessing the jury trials would take place in Iqaluit and people might come from away. Are there any programs available? Are there unique cultural issues that you have identified in your practice that would help us understand what to do in remote places like Nunavut?
Yeah, thanks, Mr. Rankin. Good question. I would say the vast majority of our jury trials actually take place in the communities, not in Iqaluit. I was just canvassing the office before I came in. We can't remember the last time we had a full jury trial in Iqaluit, but looking at the schedule, we had 2 back-to-back scheduled for Rankin Inlet in a month. Nunavut is very much an outlier when we're talking about juries, and especially when I hear the evidence put forward by my fellow witnesses. Australia or Victoria is pooling 170,000 people. We have 810 eligible individuals in Pond Inlet to serve on a jury. If we do back-to-back juries in the community and we pool 250 people each time, we expel the entire adult population very quickly. We're a traveling circuit court. I put a lot of this in my written brief, so excuse me for any repetition, but we have one permanent courthouse in Nunavut, and that's where I'm sitting right now. We travel to the 24 other communities weekly. We do 100 odd circuits a year. When we go into the community to do a jury trial, we don't have a courthouse. We set up in a school gymnasium or community hall or a hamlet office. We put a jury to deliberate into, not the most ideal situations. And then when the verdict is over, the court party gets on an airplane and comes back to Iqaluit. So, I found Ms. Donaldson's testimony extremely interesting and fascinating, and it's something I've got to follow up on. But to hear that only 10% of jurors, experience this extreme stress is something that just doesn't really apply in the Nunavut context. You'll find a quote in the paper that is submitted saying, these communities are sometimes only hundreds of people there. They're not thousands or tens of thousands. It's inevitable that our jury, those 12 people sitting on that jury, they know the accused, they know the complainant, they may, be second cousins to those people. So to think that they're not stressed or burdened by this on a very high level is a misnomer. It's Nunavut is an outlier here. Some feedback, but Nunavut is an outlier here, much like in a lot of contexts for Nunavut. But I hope I've addressed your question, Mr. Rankin.
You have. Thank you very much. Mr. Trudell, just back to the point you were exploring with Mr. Fraser, one idea I wondered about is if one were to, in a sense, find that what you called an escape exception to Section 649, so people could talk to a therapist and not violate the jury confidentiality rules. Couldn't one reinforce that by professional discipline with respect to the therapist? So in other words, if you are able, with an amendment, to talk to a therapist after the trial is over and you're experiencing, like Mr. Ferrant, whom you referenced, serious PTSD, then that therapist could be made subject to professional discipline rules if he or she were ever to disclose to anyone for any reason what they heard at the time. So we could reinforce, sort of belt and suspenders. You suggested an amendment to the section of the criminal code, but one could reinforce that with professional discipline requirements.
Yeah, Mr. Rankin, I'm in my other life, I spend a great deal of time representing professionals, and there's no question that I would suggest that we don't need to amend it because professionals are regulated very strictly, and any doctor who breached the confidentiality of the patient relationship, let alone the criminal code, would certainly risk losing their license. But one of the things that we need to pay attention to, in fairness to jurors, is the role of the media. How many cases end when the front page of the media says what the jury didn't hear, and all the evidence of the voir dires about evidence that a judge has decided is inadmissible is splashed in the newspapers, which is unfair to jurors. And it goes back to what they should be told in the beginning, that there are going to be things that the judge rules on that you're not going to hear about. So a juror could feel cheated, quite frankly, if they walk out and haven't had a debriefing and then read about it in the newspaper. And so I think that the community has a collective responsibility to respect the jurors and not make their jobs harder. So it's one of the after effects.
Thank you. And I really appreciated your testimony as well, Ms. Donaldson. I thought it was helpful that you gave us a list of specific recommendations as well. The idea that the more time would be allowed to have a voir dire to help identify problems that a judge would have without jury obviously being present, that sounds like a really good idea. But I was concerned about the other idea that you had about steps like that paint gun to limit the impact, using paint gun rather than showing the horrible pictures that would cause trauma. Isn't it true that sometimes a district attorney in your system would want the impact, the visual impact, in order to persuade those jurors of the horrible human cost of a particular murder or something? So does that always apply?
That's the rub. Prosecutors or plaintiffs in personal injury cases want to make the evidence as graphic and real as possible, because their support is going to come from jurors that feel the pain, identify with the victim. The defense, on the other side, wants to make it into more of a clinical presentation, use the paint gun situations, remove that element of emotions. Humanly, that's not possible. It does help to reduce, but if the concern is doing harm to jurors,
right, but you're not going to tie the hands in your solution, which makes perfect sense, of a prosecution that wants to get maximum penal consequence from the pictures.
Unless a judge helps to control because of the graphic sense. I mean, the parties have to talk to a judge, and generally they won't come to an agreement. I mean, they just have opposing strategies for trial.
Thank you very much, Mr. Sassy.
Thank you, Mr. Chair. Today and providing us with very, very helpful information. The first person I was wondering if I could ask a question of would be Mr. Dorr. Mr. Dorr, you were explaining to us the uptake of services by former jurors in Victoria. As I think you heard, we have the same challenge in Ontario as well. The anecdotal evidence we were provided suggested that the numbers were very, very low as well. I was wondering whether when you were devising and implementing the jury support system, whether there was any thought focused on the issue of stigma and how to work one's way around that so that jurors feel more comfortable coming forward and seeking help if need be.
Yes, thanks for the question. We carefully crafted our communications in consultation with the counseling service, and we started from a position that we start with in all areas of jury service, and that is, we say to citizens, this is the last type of conscription available to the state. So you didn't choose to be a juror; you were randomly selected from the electoral roll. There are some opportunities for you to apply to be excused if you need to be excused. If you are eligible and you're not disqualified from jury service, then you're obligated to at least show up with your summons. We go through an orientation that sort of sets out what they can expect, and then we say to them, a reaction, I'm not a psychologist, call it stress or whatever it is a normal response to an abnormal situation. And then finally, we say to them, and we really are almost quite flippant about it, but that's probably the wrong word. Is we say we won't know if you phone this 1-800 number. In fact, I don't know if people do. I get a bill from the counseling service that says this is how many hours we did. I don't know who phoned, from what trials. And it's only for the purposes of this session that I got the stats. But all I can tell you is it was 17 people, and some were from Melbourne and some were from regional Victoria. There are 13 regions. I don't know which of those 13 regions. So I think the stigma can be minimized by that sense of it is absolutely confidential and it is absolutely up to you whether you pick up the phone.
Thank you very much. Now, if I could ask Mr. Bornstein a question. Thank you. During your testimony, you were highlighting the extent to which fatigue or evidence of anxiety could lead to jurors making mistakes, making errors. It impairs their judgment. I was wondering, that's very intuitive for us. We can accept that, but could you perhaps delve into that in some more detail and sensitize us as to how much of an impact these things can have on jurors' judgment?
Sure, and thank you for giving me a chance to go into a little more detail on that. You raise a couple interesting aspects of what's going on, fatigue being one, but also the stress level, where in some of these cases, like Ms. Donaldson was describing, the trial goes on for months or years. Jurors become bored. And the first thing you learn when you observe a jury trial is that it's not at all like the jury trials on TV. And in fact, they're really tedious, even ones that are sort of sensationalized cases. Just the manner in which attorneys are required to phrase their questions and how the evidence is presented, it can drag on and on. So it's not unusual to see jurors sleeping, at least in American trials. Longer trials, jurors are clearly not paying attention for long periods of time. If they're allowed to have their phones with them, they're on their phones, and so many courts now require them to leave the phones in the jury room so that they can't do that. And fatigue and boredom are going to work against the ability to process the information pretty much in the way that you'd expect. The issue of jurors being upset by what is going on is a little trickier, where to some extent that increases their ability to pay attention. You know, if they become more alert, hey, here's some interesting pictures of the crime scene, what have you, they might pay attention a little bit more. But that can reach a point where their anxiety level becomes so pronounced that it makes it harder for them to pay attention, or they're paying attention to aspects of it that might not be legally appropriate, so it can become prejudicial in some of those cases as well. So we would describe that as an inverted U-shaped function, to use a technical language, you know, up to a point, maintaining interest, having some sort of arousal level can be beneficial, but then past a point, it can be counterproductive.
Absolutely. And my last question to Mr. Trudell, given that we were talking about lengthy trials, one of the recommendations we've heard is that if a particular trial is dealing with a horrific case, that perhaps we should consider the use of providing breaks along the way. What would your view of that be? Would that throw, you know, the administration of justice into disrepute, or is that something that you would be in favor of?
We moved to a real energized case management system in this country, in criminal justice and in civil cases. And I think that the National Steering Committee did a paper on case management. So I think that a judge will assess the case. That's what we ask them to do, and decide whether it's appropriate to take break. I'm not sure what you mean by breaks in terms of how long. I don't know what people said. But a judge can work that out with counsel and maybe consult with the juror. Jurors decide that this case is going to take a long time, and therefore we're not going to sit on Fridays or something, but not a 3-week break, but certainly shorter days, 4-day week. So if a case is going to take 4 months or 5 months, a judge is not going to sit every day, hopefully, because it's just not going to work. The juror is going to lose patience, and it's not going to work. So it's a human system, and I really do think that judges with case management are managing. They know what's coming, and so if breaks are important and the jurors want breaks, I mean, there's nothing the matter with saying to jurors, you know what, we're gonna sit till 3 o'clock today, or we might. What do you think? The foreman or somebody's going to say, let's go home, or no, we'll sit. I mean, it's a human thing. So I think it's up to the management of a case, and that's what judges are skilled to do and being trained to do more often.
Thank you. Thank you. Oh, Ms. Donaldson, sure.
Small comment on that. Many trials that I've been involved in have had natural occurring breaks, like a 4-day weekend for Thanksgiving or the holidays or the Jewish holidays in September and October. There's many breaks in a trial. In New Orleans, they break for Mardi Gras, and their court is closed for a week. So what's done in some of those situations is mini summations are allowed. So when the jurors come back, each side is allowed to give a very mini summation of the evidence that has occurred so far, just to kind of bring everyone back and up to speed with what's occurred.
Thank you. So now we're going to go to questions from people who haven't yet asked. So, Mr. Nicholson?
Well, thank you very much, and thank you to all the witnesses here. This is very important. This is the first time, my knowledge, that the Canadian Parliament has focused specifically on the needs and the concerns of jurors, and so your testimony here today is very, very helpful. First of all, Professor Bornstein, you indicated that you have put together a lot of studies over the years. Are these online, something that we could access, or is there a way to get some of that material?
The ones that are not readily available, I would be happy to send.
I wonder if we could make arrangements for that. I think that would be very, very helpful. I would
Sure.
certainly
If you wouldn't mind,
appreciate that.
Professor.
And I just pass on a comment to you, Mr. Dorr, as well. I've been in justice for quite some time over the years, and one of the things that was very helpful in updating the legislation, the criminal code in Canada, was to have a look at what Australia did. You have a federal system, the same type of law system that we have, and you have many of the challenges here. So I found it very interesting to hear your testimony today here. It sounds to me like you're ahead of us with respect, in many respects, with respect to jurors and the support for them here. And I want you to know that that's very, very much appreciated. So thank you for that. And to you, Dr. Donaldson, you indicated that there's a certain amount of stress. So you know, one case where the jurors or somebody helped pay somebody's thing. Is that being in Minnesota, they don't get any stipend at all for jury service?
No, there's stipend. I think at that time it was maybe $30 a day or $40 a day. The most that we see in the United States is about $40 a day. Large companies usually pay their employers. Government workers usually are paid for jury service. It's people who work at smaller businesses, like under, I think it's like having 10 employees, self-employed people. If I had my way, if I was queen of the world, jurors would be paid minimum wage for their service for those who are not compensated by their employers.
Eliminate basically sometimes maybe even a whole class of individuals, of people who are, are not financially well off, or minimum wage or less than minimum wage, or unemployed. You know, basically you shut them out of a system of basically serving their state or their country.
They can't. If it's a long trial, if it's a trial more than a few days or a week, those people do get shut out, but they can usually manage for a short trial. I have had numerous long trials in my career, and those jurors are definitely shut out. In fact, we will sometimes call for a special pool of 500 jurors in order to sit a panel of 8 with 3 alternates. And we're lucky to sometimes seat a panel out of those that were summoned because only about 200 show up.
Thank you very much, Mr. Chair.
Thank you very much. Mr. Fraser?
Thanks. Mr. Dorr, I wonder if I could ask you a question. We have heard some testimony during our study so far about different examples where jurors are not necessarily comfortable in their courtroom setting or arriving at the courthouse or whatever during the trial. It's been suggested that it helps to de-stress or as best as can be done, minimize stressful situation if, for example, different parking arrangements are made so that the jurors aren't arriving at the courthouse at the same time as family members of either the victim or the accused, for example, in a criminal trial, or if they have their own entrance to the courthouse. I'm wondering if you could give some examples about what is being done in the state of Victoria to try to minimize stress in the courtroom situations for the jurors themselves.
I can, as long as we remember that there are 14 districts, and I can tell you that, for instance, I'm sitting in Melbourne. The building was a purpose-built building, commissioned in 2002, and it is a perfect environment for jurors. So, as you suggest, they have a separate entrance that they enter. There's a lounge. They're given security cards as employees so that they can get in the building, clear security, get on a lift, go up to the floor that they're required to go to, and into the deliberation room they're required to go to, and it's well set out. At the other end of the spectrum, we have courthouses that were built at the turn of the last century, where we don't even have a jury pool room. The pool will gather under a tree, and then be brought into the courtroom. So there are varying degrees. We're currently in Shepparton, which is a couple of hours out of Melbourne Regional Court. The government's invested around $70 million to build a new multi-purpose courthouse that will have 2 trial courts, so 2 courtrooms that could cater for jury trials, and I sit on that steering committee, and a lot of thought and effort has gone into build a purpose-built environment for jurors. A couple of comments, if I may, just on what previous people have said. Our judges, certainly on longer trials, will build in breaks, and I just have to stress it again that we have a front end system whereby any of the personal hardship issues never get into a courtroom. And the third thing I'll say is, and it doesn't matter if you're the CEO of BHP or not, your employer is obliged to make up your pay to that which you would have expected to be paid had you not been on jury service. So I think our system has really catered for those personal stresses, not necessarily the stress related to the horrific details of a trial, but those other personal circumstances we never get into a courtroom.
Thank you.
Mr. Rankin?
This is a question for Professor Bornstein or Ms. Donaldson. Are there examples in the United States where the media or academics have really had an example of a person suffering from PTSD that has been given lots of publicity? Like, this is an issue we're studying in Canada. I just wondered if you have any other glaring examples of this issue arising in the United States, or interest that's been given to an individual of this kind.
You see some examples of jurors themselves talking in social media, but I'm not aware of any media attention only.
There's been some. The most recent one I can think of is the trial of the Aurora, Colorado theater shooter. So you might remember the case a few years ago of the man who went into the midnight screening of a movie and with several assault weapons in Aurora, Colorado. I think his last name was Holmes, Jeffrey Holmes, maybe. There were a lot of media reports of his trial of jurors breaking down in tears while testimony was being presented of, the pictures of people who were bleeding and had died that were a necessary part of the trial, but were extremely hard for jurors to view. And many of them were interviewed after the trial ended and talked about just how difficult it was.
One quick
So I think Ms. Donaldson was going to.
In many personal injury trials that I've been involved in, we frequently will see a juror cry. And in working for the defense, I'll sit there and say, oh, we just lost that juror. They're going to vote for the plaintiffs. Lo and behold, they're able to separate that out. And we find out afterwards that they voted in our favor. So crying, what you observe, the emotions you observe, I think are just human emotions. And some jurors are just able to separate that out.
And I have to tell you, as a person who watches American movies and reads Michael Connelly novels, I have no idea how these jury consultants work. So it was fascinating. Like, I can't imagine a 4-month jury selection process. But I guess my question that I wanted to ask you is there, when you do the initial vetting of jurors, do you look for signs of emotional instability? Do you, as a psychologist, are you able to say, we really better steer clear of them because I can see trouble down the road with that particular juror's mental and emotional stability?
Yes. There's two ways. If there's a written questionnaire, if we start getting unusual answers, responses, or outrageous responses, some venting, anger, we know that this is a person whose emotions can't be controlled, and we're going to look closely at that. But generally, we don't know until they've come into the courtroom and they're seated in the room and start to be questioned that we see that there's something, not right about them.
These peremptory challenges or for cause when a person's emotionally... For cause, right?
For cause.
Yeah.
Well, we try for cause.
Yeah.
At a judge's discretion.
Right,
He says that's what you have peremptory challenges for.
Can I speak to that briefly? The problem is that many people can fake it. And people who perhaps have emotional stability don't have it 24/7. So depending on what's going on in their lives otherwise, or what evidence might be presented at trial, they might not respond in an unstable manner. But if they had a fight with their spouse that morning, or who knows what, then the emotional instability could manifest itself, which makes it much harder.
Thank you very much. Mr. Cooper?
Just a question to Dr. Donaldson or Mr. Bornstein. We've looked at jury support programs provided in a number of different provinces from 2 states in Australia. Are you aware of any jury support program in any U.S. state, or perhaps provided by a court in the U.S. that is a model, or that we perhaps should look to as we consider the range of services and the scope of what a proper jury support program should look like in Canada?
Good question.
It's a good question. None leaps to mind. It's in my experience, it's done very much on an ad hoc basis. Individual courts, individual judges. In some cases, there are a few jurisdictions which are experimenting with things like orientation videos, or in some states have raised the level of pay, addressing some stressors like that. But I can't think of one that has been more comprehensive in terms of addressing the issue. Texas does.
Texas has instilled legislation that has a program such as that. And I actually have a couple of articles that I will forward to the committee of not only a summary of what state courts have concluded and are implementing as changes, and also to answer your very question, the states, because I know like New Jersey doesn't have a formal program, but it's something that everyone in the court system is sensitive to. So I will send you those articles.
Mr. Dorr, can you let us know the state of Victoria? What is the cost to the state of the juror support program, and is there any contribution from the national government?
The answer to the second question is no, and the answer to the first is less than $10,000 a year. We are really. Sorry, I just got a bit of back. I'm getting a bit of back feed there. We are really paying the cost of the hourly rate of a counselor, which is around $170 an hour, and some of the promotional, collateral, the pamphlets and those sort of things. But the issue is that it is a tap that may have to be turned on as the uptake is increased.
There's just a second question. You've heard us talk about our Section 649 of the Criminal Code that prohibits discussion of deliberations post-trial. And as Ms. Donaldson mentioned, in the United States, there is no such restriction on the jurors. Nobody can compel them to speak, but they have every right to go speak and write books and talk about what the deliberations are about. What is the system like in Australia? What are the rights of jurors, and is there an exception for mental health counseling, et cetera?
Yeah, I wish you hadn't said that writes books, because when I speak to jurors and when I speak to students or anybody else, the first thing I say to them is, if your understanding of the jury system in Victoria is based on American TV, you've got to get that out of your head. And I always say, that they go write a book, CNN can interview them. For us, Section 78 of the Act sets out, it sounds a similar provision to what you have, which is that, the deliberations are sacrosanct. That a juror can't discuss the deliberations. Interestingly, it says in the course of there is Section 78(5) that says nothing in those previous subsections prevents a person who has been a juror from disclosing any statements made, opinions expressed, arguments advanced, or votes cast in the course of the deliberations of that jury to a registered medical practitioner or a registered psychologist in the course of treatment in relation to issues arising out of the person's service. So it's very explicit.
That's that's very, very helpful. I think we'll look at that very closely.
Yeah.
Thank you.
Yeah.
Thank you very much. Mr. Fonseca had a question, and then. Yep.
Well, thank you, Mr. Chair, and this is a follow-up to the Chair's question, Mr. Dorr, in regards to cost. Compensation costs for the state of Victoria. What would compensation be for all those wages that you'd make up for all the jurors?
Oh, okay.
That costs the Treasury.
Yeah. Sorry. So you mean the actual paying jurors to be at court?
The stipend, yes.
Yeah. So we pay a whopping $40 a day. I beg your pardon?
Oh, they don't pay full wage.
The employer in Australia, he was saying the employers have to pay the employees during their jury service at their standard wage, regardless if they're a CEO or not, is what he had said. Sorry, Mr. Dorr.
Go ahead.
I'm just letting Mr. Fonseca know what you said. Maybe Mr. Fonseca can now revise his question.
Well, I don't know if he would have an estimate on that cost to the employers.
I need to just make one clarification. In Victoria, so in Australia, there is a Fair Work Act that states, Section 11 says the employer has got an obligation to make up the pay of a juror. That act says that obligation ends after 10 days. But the next section of that act says if a state law is more beneficial, then the state law will apply. So in Victoria, because of the wording of our legislation around the obligation of the employer, it means that we supersede, we override the Fair Work Act. So, but in other states, so in Victoria, we pay $40 a day for the first 6 days, $80 a day thereafter, but the employer's got to make up the pay. In other states, they'll pay more than $40 a day. I can't quote all the numbers. And then at day 11, they'll pay even more, knowing that the employer doesn't have an obligation to make up the pay. The answer to your question around the cost to employers or to the economy, that would be an economist that would have to answer that question. I just can't answer it.
Can I just ask, is Victoria the only state that has that rule that says that after 10 days the employer has to pay, or is it?
Well, it's not so much that the rule says that the employer, the 10-day rule, the legislation in Victoria, Section 52(2) says, despite any inconsistent term in a contract of employment, an employee who has been summoned for jury service and who has attended court, whether or not he or she is actually served on a jury, is entitled to be reimbursed by his or her employer an amount equal to the difference between the amount of remuneration paid under Section 51 and the amount that he or she could reasonably expect to have received from the employer as earnings for that period had he or she not been performing jury service. So it's silent on how long that period is, whereas the federal legislation says the obligation to the employer ends at 10 days. But then the federal legislation then says, but if you can get a better deal under state legislation, so you can. So I can only say that in New South Wales, they don't, their stated obligation for the employer is not open to interpretation to allow the 11th day to be the employer's obligation. I don't know if I've answered that correctly, but or succinctly, but each state has got varying ways of compensating jurors.
Good, thank you. Mr. Fraser, you said you had
Oh,
one?
yes, thanks, Mr. Chair. Just very briefly following up on the chair's question regarding, I think you quoted Section 78.5. There's an exception in there to allow a juror to discuss things with a medical practitioner or whatever the terminology you used was. What act is that, first of all?
Act 2000.
What act?
The Juries Act 2000, VIC, so it's a Victorian legislation.
Very good, thank you. And are you aware of any problems or criticism or any litigation arising on that particular section?
No.
All right, thanks very much.
Excellent. Everybody good? So, I think Mr. Trudell wants to say something before we break. Mr.
Chair,
Trudell?
could I just raise one potential issue? And I was very interested to hear about the struggles in the North in terms of trying to select a jury. And of course, it paves the way for restorative justice. But there are sections of the criminal code which demand a jury trial for murder, for instance. And there are sections of the criminal code where the Crown must consent to a re-election. And when you are perhaps looking at legislative amendments, it may very well be that that might be something that garners some attention, so that if I could re-elect to have a judge alone instead of a jury trial, I may want to do it, but the criminal code prevents that in certain cases.
Thank you very much. Thank you very much to our very distinguished panel of witnesses. I don't know that we've ever had a more internationally diverse group. So thank you very much, and meeting adjourned.